All rise. All persons having business before the honorable judges now residing over the District of Columbia Court of Appeals. Draw near and give your attention. Now, citizens of the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Thank you. Good morning. We have two judges here on the bench, and Judge Beckwith is participating remotely, as you can see. And we have three cases on the calendar this morning. We'll take them in the order in which they appear. The first case is WISE-ROJAS versus U.S. Department of Agriculture.
Thank you, and may it please the court. My name is Mustafa Ali. Together with Christopher Wright, I represent Lori WISE-ROJAS. I would ask to reserve 3 minutes for rebuttal. In an unemployment compensation case where an employer states more than one ground for terminating an employee, the employer must make clear whether it would have fired the employee for each reason standing alone or whether the reasons together justified discharge. That showing is part of the employer's burden for proving misconduct. In this case, the ALJ found that USDA fired Ms. WISE-ROJAS for two reasons that together justified her discharge. USDA does not contest that finding of fact on appeal. And that means USDA had to prove that each of the reasons for termination constituted misconduct. The critical point is this: if USDA failed to prove, or the ALJ improperly determined, that either lack of candor or AWOL constituted misconduct, this court must reverse. With that in mind—
Can I interrupt? Do you think that they both have to also constitute gross misconduct in order for us to affirm that aspect?
I do believe that that is the best reading of this court's case law. This court hasn't made clear whether or not that is the correct reading, and will concede that. But OAH has issued rulings to that effect. And we would argue that that is the correct reading of this court's case law, specifically in Smithsonian.
Why does that make sense?
Why does that make sense? I think it makes sense because if you're going to find that someone was discharged for multiple reasons, but neither of them separately would have constituted discharge.
Well, I thought it was, you have to find that the person engaged in some sort of misconduct, right? And then the question is the degree of misconduct, and that affects the time for which the person is disqualified from receiving benefits. But you know that if you find misconduct, they're going to be disqualified for some period of time. So why do you need to have both instances or counts of misconduct be gross? Why isn't it enough logically to say, well, if one of these is gross, then this person is going to be disqualified from receiving benefits for a longer period of time?
Well, I think I don't know that it's necessarily clear that you have to agree with our view on this, but I would say that there's a certain logical disconnect between a finding that each reason standing alone wouldn't have justified discharging someone in the first place, but one of those reasons alone could rise to the level of gross misconduct. That seems to be somewhat disconnected from the severity that this court has required for finding of gross misconduct.
Well, why? I mean, I want to hear what the affirmative argument is, right? I mean, if one of the instances of gross misconduct is something, sexually, assaulted someone in the workplace, and, the other instance of misconduct is that you were repeatedly late to work over a 6-month period, right? And they said, together, we fired this person and, think that they engaged in misconduct, but only one of them is gross misconduct. Why does both have to be gross misconduct for it to be disqualifying for that elongated period?
I think that requirement flows from the way that the employer has chosen to make its case. An employer is always free to say, we fired this person for 2 reasons, and one of these was so severe that we would have fired them for that standing alone. By making the case that neither
But what,
reason,
in my hypothetical, the employer hasn't said that. The employer has said, we fired them for both reasons, right?
right? I suppose
But one of them is definitely gross misconduct.
I would argue that in your hypothetical, one of those reasons is an independent reason for discharge. And where you have
But
one,
I thought you said it depended on what the employer was saying, and if the employer is presenting this as, we gave 2 reasons for firing this person, both of them were essential to our decision to terminate this employee.
I think in that case, you do have to prove that both of the reasons separately constituted gross misconduct. Otherwise, you can't make the finding that this person was terminated for gross misconduct alone, because you have a mixed determination of gross and simple misconduct, and the employer has conceded that neither reason alone justified discharge, and misconduct has to be a finding based on something that would have justified discharge. So you have to look
If the
at.
Can I ask you
employee
about-
does,
Sorry.
go ahead, Judge. Becker.
Sorry, can I ask you just to clarify that? Because in the transcript, I recall the employer saying that they wouldn't have discharged for AWOL alone. Did they also go on to say the opposite, that they wouldn't have discharged for the dishonesty alone, or is that just what the ALJ inferred?
That was a reasonable inference of the ALJ. I would say the employer should be held to that inference in this case for a few reasons. The first is that's a factual finding that's owed deference by this court. And second, the ALJ in this case expressly gave USDA's counsel the opportunity to ask that mirror question. I don't know that you could have it more clearly than you do on this transcript, where the ALJ said, I'm only asking about AWOL. And if you want to ask about lack of candor, you can do that. And USDA's counsel declined to do that. So they should be held to that inference here.
But isn't that different? Declining to get it on the record is different from saying it is on the record.
I agree that it's certainly different, but what you have to look at is the regulatory requirements, where the burden of proof remains on the employer in these cases. And so where the employer chooses not to make its affirmative case, I don't think that there's any reason on this record to second guess the reasonable finding by the ALJ on that point.
I take it that you don't dispute that the lack of candor was in itself gross misconduct.
We would argue that the finding of gross misconduct in this case as to lack of candor rested on factual findings that don't necessarily have substantial support in the record. And while on remand, the ALJ might rightly find that this was still gross misconduct without those findings as to the consequences of Ms. WISE-ROJAS' actions, her lack of candor, I don't know that there's enough here for this court to affirm, if it agrees with our argument, that the findings regarding the consequences of Ms. WISE-ROJAS' actions weren't substantially supported by the record.
Well, I'll tell you where I was going with my question, and I'll respect that you have that point. If we assume that the lack of candor alone was gross misconduct, and the employer said, well, you not only did that, but you also engaged in AWOL, it seems like the combination is gross misconduct. It can't be less than gross misconduct. It's gross misconduct plus.
Well,
And we're firing you for that gross misconduct plus. That would seem to satisfy the requirement that the reason for the termination was gross misconduct.
I think there's a predicate question that the employer has to answer, which is, did you fire this employee for each reason standing alone or together?
Suppose the employer says it was together. We don't know what we would have done if there had only been one of these things. We might have fired her, we might not. But together, it was gross misconduct in spades, as it were. That was enough for us.
I believe under this court's case law, the employer has the burden in a critical mass case like this one, where it relies on 2 mutually dependent bases for termination, to prove that both reasons or all reasons that contributed to discharge amount to misconduct in the first place. And so,
Well, I think, yes, they do have to amount to to misconduct, I
Right.
suppose. But if even one of them amounts to gross misconduct, then it would seem as if the mass is gross misconduct, amounts to gross misconduct.
I think you might be able to come to that conclusion if the employer has proven that each reason at least rises to the level of misconduct. But they haven't done that in this case as to the AWOL. And because they haven't proved adequately under the regulations that AWOL constitutes misconduct, it really doesn't matter whether the other
Oh, I
reason
see.
is
You
gross
think they didn't
misconduct at
prove-
all.
You think there's an issue as to whether not showing up for work for an extended period of time without a good excuse constitutes AWOL?
It's not whether it constitutes AWOL, it's whether the conduct in this particular case rises to the level of
You
misconduct.
don't think that
And
rises to the level of misconduct?
not in this case, because the finding of misconduct made by the ALJ rested on a finding of a rules violation. And the regulations, 7 DCMR 312.7 makes clear that where a finding of disqualification is based on a rules violation, the ALJ has a separate legal duty to find that the rules were reasonable and that they were consistently enforced. And that simply was not done here. And this court has repeatedly
Well,
said.
I assume you think that the rule that you have to show up for work is a reasonable rule. So it's whether or not they consistently enforced the rule that you would get fired for not showing up for work.
I do believe that's the critical point in this case. I would argue, however, that the ALJ has a separate duty to make that finding, regardless of whether it's clear on the record. The regulation doesn't say that the ALJ can ignore its duty to make the necessary regulatory findings, even if it's.
How long was it that she failed to appear? It was
It's 420 hours of AWOL is what's in the notice of proposed removal.
in days. That's
I believe it's 3 months or so. I think that's about right. But what we have on the record here is Mr. Schaefer, who's I believe the director of the unit, actually says that, he answers a hypothetical by the ALJ, which is, would you have fired someone for AWOL of this amount standing alone? And he says, applying the appropriate factors, I don't think I would have. And so what we do have on the record here is at best uncertainty about how consistently this rule about what constituted excessive AWOL would have been applied depending on facts. And that's why 312.7 exists. And that's why the requirement of finding consistency exists, because rules on paper may say one thing, but how they're applied in practice differs from workplace to workplace and fact pattern to fact pattern.
and clarify for me, the USDA identified the rule violation as failing to show up for work. Were they that specific in identifying what the rule was?
They were not. The notice of proposed removal states that I find your AWOL to be excessive, or I find your excessive AWOL to be contrary to your duties as a federal employee. I don't remember the verbatim language, but it's one of those two. But it's a fairly clear statement that the length of AWOL was found to be excessive. And that's reflected as well in the testimony by Dr. Cole and by Mr. Schaefer that they found the AWOL to be excessive. I believe USDA's counsel expressly asks that question. You found the AWOL to be excessive, and the answer
And
is
when
yes.
considering the AWOL, we really, your position is that we can't consider the fact that your client gave a false reason for not appearing.
I believe those are actually quite separate. The testimony is fairly clear. There's a colloquy back and forth between the ALJ and Dr. Cole, where the ALJ asks, assume none of this lack of candor happened, would she still have been placed on AWOL? And Dr. Cole's response is yes, because there was no approved leave status for periods of incarceration.
Well, sure.
And
But that doesn't quite answer my question, right? I mean, yeah, someone doesn't show up for work, they are presumably placed on AWOL, right? But if you add into the mix that, she's giving false reasons for why she's not showing up at work, which then raises all sorts of questions, we can't consider that, you think?
I don't believe that the lack of candor should be considered in determining whether or not USDA met its burden of proving a rule violation under its AWOL regulations, whatever they were. And the critical question really here is whether the ALJ, it's not even about USDA's burden, it's really about whether the ALJ met its requirements under the regulations to make the finding that these rules were reasonable and consistently enforced. And that just didn't happen in this case. And this court has repeatedly said that those are material facts. They have to be found by the agency. And when they're not found, this court is constrained to reverse. And so at a minimum, we would argue that on these facts where the ALJ was required by regulation to make those findings and didn't make those findings, at a minimum, this court has to remand for it to make those findings on the record. And we actually go further and say that because USDA didn't introduce any evidence as to the nature of its rules, what was in them, what constituted excessive AWOL, how these rules were applied, this court actually should follow its precedent in cases similar to this, where there's nothing on the record to make such a finding and reverse outright.
Well, what is your response to the, to the Department of Agriculture's argument that they basically treat this as so obvious, and we could take judicial notice of a bunch of cases that deal with removals and terminations for things like this. So what's wrong with that approach?
A few things, Your Honor. The first is that this court generally does not take judicial notice of facts not presented to the fact finder below. That's just a general rule that this court applies. Of course, it could take judicial notice of cases if it so wanted. It has the discretion to do so. But all those cases tell you is that the facts of those cases occurred. It doesn't tell you anything about how USDA, as a separate agency of the US government, applied its rules. And the US government isn't a monolith, and different parts of the government may apply rules that are written similarly in different ways. And it's that variation in how rules are actually applied in practice, which is that's what's behind the requirements of 312.7 and why this court requires an investigation of how, in particular circumstances, how a particular employer actually enforces its rules in practice. And that's meant to protect employees. And this isn't just about Ms. WISE-ROJAS. It's about the general statutory scheme that the council had in mind when it passed this law, which was, this is a humanitarian statute. People are presumptively entitled to these unemployment benefits. And if you want to disqualify them from these benefits, which again is a separate question from whether or not you can fire them. No one's arguing here that Ms. WISE-ROJAS is entitled to her job back, or that what she did, didn't entitle USDA to fire her. But it's a separate statutory question whether or not USDA has met its burden of disqualifying an employee from presumptive benefits that the council has said people should be entitled to unless the employer meets a specific burden. And USDA just didn't do that in this case, and they shouldn't be allowed to avoid that burden by asking this court to step into the role of fact finder and find facts where there's really nothing in the record to begin with. This is actually even more intrusive than the average case where someone says, take judicial notice of something or take notice of something that's already in the record, but the ALJ didn't point to. They're asking this court to step in, go on Westlaw and look at the case law generally, and find from the ether of case law that this was misconduct. And that's just not generally the role that this court has. The facts about whether or not a regulation was complied with and whether or not a rule violation was a violation of a rule that is reasonable and consistently enforced, that's something that the fact finder should be doing in the first place. And that didn't happen.
On that score, I wonder if you could clarify something for me before you sit down. We've talked about rule violations and we've talked about misconduct. Now, it's a rule violation if an employee doesn't show up for work when the employee is supposed to. Okay, and they could terminate her, I suppose, for that. But if I understand correctly, in this case, the reason she didn't show up ultimately was that it was beyond her control to show up because she was incarcerated. Is that true for the entire 420-hour period that we're talking about here?
Based on the record, yes. She was incarcerated as of the day following she actually had 1 day of approved leave to leave early. And then the day after that, she was arrested and the record supports a finding that, she was denied bail and incarcerated from that period on.
So if she was unable to show up because she was incarcerated, why is that misconduct?
Well, we would,
Forget about whether it's gross or simple misconduct. I'm not sure I understand that that's misconduct. It's a rule violation. You're supposed to show up, okay? If you can't work here, it doesn't matter why you can't work here. They can fire you, okay, but why is it misconduct for purposes of the unemployment compensation statute?
I mean, arguably, it wouldn't be misconduct because the statute requires that misconduct be willful. And I don't know that anyone really intends to be incarcerated.
I mean, if she were hospitalized for 420 days,
Right.
or 420 days
Hour-
or hours, presumably one wouldn't say that she'd been terminated for misconduct.
We would agree with that, Your Honor. And frankly, the reason that that's not in our briefing is it wasn't argued below. We know this court isn't generally friendly to arguments raised for the first time in appellate.
You're in no position to ask us, given the nature of your argument, you're in no position. Right, okay,
Right.
good.
We'd certainly take the argument if you'd like it, Your Honor. Thank you.
Let us hear from opposing counsel and we'll give you a few minutes in rebuttal.
Good morning. May it please the court. The unemployment
If I
compensation
may, let me just ask you to identify yourself for the record, please.
certainly, Your Honor. I am Jane Lyons. I'm an assistant United States attorney in the civil division of the U.S. Attorney's Office here in the District of Columbia, and I'm here on behalf of the Department of Agriculture. But I'm also here to defend a decision by an administrative agency of the District of Columbia, because I think part of what's been going on this morning is this sort of conflation of couple different things that are happening, right? The employer decides to fire an employee for its reasons, and then there's an unemployment compensation proceeding that is triggered by an application for those benefits. And the court's decisions have recognized that the Venn diagram, if you will, of misconduct is not completely overlapping. There can be employment misconduct does not lead to the loss of unemployment compensation benefits. I guess I'd like to start, Judge Glickman, where you toward the end, where you asked about the status of the petitioner with regard to incarceration. On this record, I do not believe, with all due respect to my friend on the other side, that there is any evidence about when she was released. What there is in the record is the execution of a power of attorney about 10 to 12 days after she may have been incarcerated. But let me just state clearly, I would agree with you, Judge Glickman, that if the employee were only incarcerated and that was the reason for being unavailable for work, that would not constitute misconduct by itself. But where the employee goes well beyond that and executes a power of attorney that she gives to her son, who then, and this finding is made by the ALJ, the son acts at his mother's direction to obtain application for Family and Medical Leave Act benefits, and then submits that application over a series of emails and statements to her supervisors that constitutes leave fraud. That's just gross leave fraud. And that sort of blatant misconduct is not the kind of thing that is captured in the cases regarding rules. The rules cases are about what if you violate the rules that you're supposed to actually put in effort at work while you're at work, or what if you arrive a few minutes late for work? Those kind of workplace rules cases are not what we have here. The framework for analysis is from this court's decision in Morris versus EPA, which instructs that proof of repeated absence from work without excuse is prima facie evidence of gross misconduct. The only thing the Department of Agriculture had to prove, they had to prove two things. One, that they actually fired her for the lack of candor and the 3 months of being absent without leave. The second thing they had to prove was that misconduct mattered. And that's what this court's cases have in terms of the employer's burden, and certainly the testimony of the two supervisors unrebutted in any way, despite Ms. Rojas being present at the hearing, She remains silent, as is her right, but the result of that is that it was reasonable for the ALJ to attribute the conduct to her and to infer that it was gross misconduct. Because after all, 5 consecutive days without calling into work is misconduct under this court's decision in Butler.
So counsel, you described what Ms. Rojas did as leave fraud. So she was seeking approved leave under the FMLA. Was she seeking paid leave?
She was seeking paid leave. She was granted paid leave in the initial February 21 timeframe. She asks her supervisor on February 9th for leave that afternoon to attend to an emergency, a personal emergency, which of course was immediately granted. But then she doesn't come to work on February 10th, and she is given sick leave for those days. She is given leave until the agency realizes that it has significant doubt about the reasons for her absence being illness. She is given leave. I'm sorry, Your Honor, I think I forgot your question. I'm so sorry.
I was asking whether the leave that she was seeking was paid leave.
So that what I was trying to get to is that was paid leave that was extended to her in the first instance. Family and Medical Leave Act can result in the granting of a combination of both paid and unpaid leave, but yes, she was certainly seeking paid leave.
And I see that the ALJ described this as a kind of leave fraud, but that does seem like a slightly different characterization of the misconduct than your own description of, right? I mean,
I'm not sure I'm following you, but they're
the reasons for
intertwined.
the initial reasons for termination didn't say we're terminating her for engaging in leave fraud.
The way that the employer phrased it in its notice of proposed removal and its removal decision was lack of candor. And it really is the lack of candor reflected in these actions that that the government finds intolerable in employees. And this court's cases
I mean,
will
maybe I'm
represent
just
that.
trying to draw just to find a distinction, but I mean, lack of candor seems to be, you know, you're lying about why you aren't where you should be, which is at work, right?
But
You know,
also lying about trying to
didn't-
get benefits, not just maintaining
But I
employment.
guess that's my question. Is that clear from the initial termination notice? Because it doesn't seem so clear.
Lack of candor is a broad kind of umbrella term. I would tend to agree with you about that and the way it's used here. It sweeps in both the misstatements and the misrepresentations, the false documentation, and the requests for paid benefits, essentially. So I think it encompasses all of that, Your Honor. I think the way that the decision is written, and keeping in mind that it is not written for an unemployment compensation determination. What this court does is look at the record that's admitted.
It's not written for an unemployment benefit determination, but surely USDA understands that how these termination decisions are written will impact future benefit requests down the road. I mean,
One would hope so. One would hope so. But
Right.
what my point, I think, is just a smaller one, which is that the attention is on what happened and why. And of course, a lot of what's important about the notice of proposed removal and the removal decision are the facts that are contained in there. That then this court usually looks at kind of holistically to decide whether it meets the standard for gross misconduct within the meaning of the unemployment compensation statute.
I take it that one way to think about this, although it's not clear our cases have said this, is to say the employer doesn't have to, when it makes a decision, categorize, oh, this is gross misconduct, this is simple misconduct. The employer can say, we're firing you for the following reasons. And then when the case goes to the Department of Employment Services and then ALJ, the question before the ALJ is simply, okay, Do I find the facts to be as the employer said? And if I do, are those facts as a whole, do they rise to the level of gross misconduct?
I think that's exactly right. Judge
Well,
Wentz.
I'm not sure it's exactly right, only because that we do seem to have said that in these cases involving multiple grounds for misconduct, if the employer is relying on more than one ground, then each individual ground has to satisfy certain standards. I'm wondering where that comes from and why we put it that way.
I think that one of the first principles of this unemployment compensation statute and applying it is this sort of verification that the employer, that the reasons match, that the employee wouldn't be deprived of unemployment compensation benefits for some new and invented reason that didn't cause the employer to fire them. So I think that's the first level. And obviously that's not a concern in this case. The evidence is identical. The evidence is admitted at the unemployment compensation hearing and it's unrebutted. So I think that's the first step. In cases where the employer offers, I remember a case about the zoo guy who's parking cars on Sunday someplace else. He kind of has a side gig, but his supervisors maybe letting him go do that. It's a little unclear and the record's kind of a mess. And the employer there offered, I think, 4 different reasons. I think where that is the record and the court has dealt with that kind of situation, it has been probing the adequacy of any of the given reasons and where they start to fall off. And where you run into a situation like that, where the supervisor might have been giving permission. Then you're getting those mitigating circumstances in that would take you out of gross misconduct, perhaps down to simple misconduct. But I think Hickey versus Bomers is pretty instructive here. That case involved a legal secretary who failed to advise her employer, a very small employer, about absences related to her illness and her recovery from surgery. And while the court found that there wasn't enough evidence in that case of her deliberateness and willfulness to support gross misconduct, it found basically that the illness was the mitigating factor. Here we have the countervailing, aggravating circumstance of fraud. And on this record, I do think it is an easy jump to get to gross misconduct. I would also point the court to, a place where it has been found to be gross misconduct is, Brown versus Hawk One Security. Gross misconduct is found where a security guard provoked a fight, which is that kind of criminal kind of activity that is on par with what we have here versus Rodriguez versus Filene's Basement, which, by the way, is a case where the ALJ inferred the wrongful conduct from a one-sided record, which is what we have here, but also 3 instances of disrespectful and rude customer relations effort is found to be simple misconduct. And this is a very different situation, more on par with Tyler versus GW Medical Faculty, where that's about lying. That's the employee who's lying during an internal investigation and is fired for it. And the only thing that constitutes misconduct for sure. And then again, you have a record where it's unclear what the supervisor may have told that may mitigate that from gross to something else.
So
Ms.
There are no
Lyons,
mitigators.
I'm sorry, Judge Easterly. You said, I think, that this isn't really a violation of rules case, that it's, it doesn't fall into that category. Is that an argument that you made in your brief? And I ask that because I know you make quite a bit of an argument about the reasonableness and consistency of the rule application. And can you just remind me whether you are making this this is not a rules case argument?
I was trying in my brief, Your Honor, and I may not have done it as well. I've thought a lot about the case and getting ready for oral argument. I was trying to distinguish some of the rules cases in my brief. I think now, perhaps on further reflection, that it fits more neatly into, it doesn't really fit neatly. It kind of has one foot in both set of cases. But I think it fits more neatly into the framework from Morris versus EPA, which of course shifts the burden. Once the employer satisfies its burden, it shifts the burden to the petitioner to establish that illness was the genuine reason for the absence. We don't have enough on this record to know what was the reason for the absence. And even if it was incarceration, even if it was, the signing of the power of attorney and the acts that are undertaken vitiate the excuse that that would otherwise provide.
But you seem to concede that normally in a rules violation case, the ALJ does need to make findings about the reasonableness and consistency of the application of that rule. Is that correct? But you just don't think that the absence of such a finding in this case is a problem. I mean, in your brief, you were saying it's not a problem because you can take, judicial notice of all these cases, although I do have a question about how good how consistent in themselves those cases are, but now you seem to be saying it doesn't matter.
I would say not so much it doesn't matter, but that the whatever the missing link might be, it's supplied easily by the court's framework in its decisions. Decisions like, is it Butler? That supply the parallels, the guidelines for showing up to work. How many days can you not show up for work and not be guilty of misconduct within the meaning of the statute, or have abandoned your job? Because that's another way of looking at this.
It seems difficult to look to our cases to apply some sort of set rule for how many days you can't show up to work. On this record, where it seems like actually Ms. WISE-ROJAS's superiors were trying to work with her, trying to figure out what was going on, trying to figure out how to get her leave. And so in that situation, in that scenario, to then lift from a different agency and a different group of people and a different set of facts, some sort of set blanket, 5, 10, 30 days of absence is definitely misconduct. That seems inappropriate.
I don't think you need to do that here to affirm the ALJ's finding, Your Honor. We're not asking for any particular magic number. It will probably vary, as you say, in a wide range of employment contexts. The United States government being a very large employer in the District of Columbia. But I think the point is, for the managers, they cannot tolerate the amount that they have been lied to, and then the result of that is a significant amount of absence without leave that they choose to act on when they chose to act on it. And that is going to vary by supervisors, by agencies, but we would certainly expect all federal managers to take the kind of prompt and effective action to curtail the fraud that we see in this case. And we would respectfully ask that the court affirm a finding of gross misconduct here.
Can I just ask one more question?
Of course.
What were the ALJ's findings with respect to fraud? Or if you just remember generally, was that something she was getting at?
I don't want to misspeak, Your Honor.
I asked because I just read the transcript and I don't remember it being a real focus, though I myself may have not been focusing.
In terms of the ALJ's final order, which appears, the analysis really appears at JA 9 and 10. It goes through and talks about and credits Dr. Cole's testimony in detail about the claims about serious illness or incapacitation and how those evolved, and how the manager came to suspect it and then gave 2 opportunities for the son and or Ms. WISE-ROJAS to respond to that revised view of reality. And she concludes on page 11 of the joint appendix that that constituted leave fraud. And dishonesty within the meaning of the DOE's regulations. Of course, the regulations recognize that dishonesty is a basis for misconduct, and dishonesty has a spectrum. There's a difference between telling your boss you were 15 minutes late for work because you had a flat tire when you really overslept, but you overslept 7 times in the last month, and he's going to fire you if you lie about that. So that's one kind of, much less egregious dishonesty. And this is at the other end of the spectrum. And that's why this should be found to be gross misconduct. Thank you.
Counsel, thank you. Mr. Ali, I'll give you a few minutes in rebuttal.
Thank you, Your Honor. I'd like to start by just making one thing very clear. Ms. WISE-ROJAS, in her initial briefing, argued that USDA had to prove separately that both reasons for discharge constituted misconduct. This was an argument made very clearly in our briefing. USDA did not contest that in their briefing. And so this court can take that as uncontested on appeal, and it should take that as uncontested on appeal because USDA declined to argue otherwise. I'd also like to address counsel's argument regarding prima facie evidence of misconduct. This court has found that repeated absences can constitute prima facie evidence of misconduct. But in Benjamin, which is a case involving a finding of gross misconduct and an affirmance of an ALJ's decision of gross misconduct based on repeated violations of an employee's attendance rule, the ALJ affirmed the claim examiner's determination that it was a violation of the employer's interests to violate that rule. But this court separately noted that the ALJ complied in its final order with the requirements of 312.7. Benjamin demonstrates that the requirements of 312.7, where the determination of disqualification, not the determination of to fire someone, but the ALJ's determination of misconduct and disqualification rests on a rule violation, the ALJ has to make the findings under 312.7. And what we're arguing here is the ALJ simply didn't do that. And the framework is established not by generally what exists in the facts, but by how the ALJ decides the case. And the ALJ here determined that Ms. WISE-ROJAS's conduct was gross misconduct because it constituted repeated and unexcused failures to comply with the employer's requirements for time and attendance. That's a rules case, and that's why 312.7 has to apply and why this court should reverse. Unless there's any further questions, we would rest on the arguments in our brief and ask that this court reverse the determination of disqualification.
Thank you. Counsel, thank you both. The case is submitted. We'll call the second case on the calendar. Zeta Phi Beta Sorority versus Valerie Hollingsworth-Baker.
Morning, Your Honors. Robert Floyd. May it please the court. Apologize to keep my mask on. I didn't get my certification in. I represent Zeta Phi Beta, and it's an international sorority. I represent the board of Zeta Phi Beta as well. Appellee in this case filed a complaint when she was the president of the international sorority. She had been suspended by the board for misconduct in office, and she argues that the board did not have the authority to suspend her from her position as president, only to recommend suspension, and that she as president was the only person with authority to actually suspend her from her own position. The board could remove her from the position of president, but that's not in this case what they elected to do. appellees,
We're familiar with the facts. I'm not quite sure that you're accurately recounting what Ms. Hollingsworth-Baker's complaint was, but I want to ask first about mootness and whether this case is moot. We got a statement yesterday from Ms. Hollingsworth-Baker saying she is no longer in the role of the International Grand Basilius, and also that this matter is under active arbitration. And so I'm wondering why should we still be involved in this?
thank you. You're right. The case is on the merits before arbitration. Prior to the case being sent to arbitration, the lower court ruled on temporary injunction. It's not entirely clear to me that that injunction can be before the arbitrator in order to lift it. With respect to her position, yes, she was.
Has anyone asked the arbitrator, can you say, to either suspend the injunction or to issue a new injunction? Right. I mean, my understanding of the statutory scheme is that the statute gives the trial court in this case power to issue temporary equitable relief until arbitration begins. That's not exactly, I'm looking for the language of the statute right now. That's not exactly what the statute says. And then thereafter transfers power to the arbitrator to provide equitable remedies to the parties before her. And so it seems that although the timing may be unclear, the statute seems to envision a shift of power and a sunset of the trial court's power. I'll just poetically say a sunrise of the arbitrator's power. And given that arbitration began in this case, I believe in February of 2021, I'm wondering why we aren't well into the realm of the arbitrator's authority. And it seems quite odd that this preliminary injunction would persist when this case is being actively litigated before the arbitrator. Can you speak to that?
Only in that I appreciate your honor's understanding of the statute. It is not that clear to me. It's clear to me that the lower court had the authority prior to the case being moved to arbitration to order the injunction. The arbitrator would have also had under not only the arbitration provision in the contract between the parties, but generally speaking, would also have had authority to provide injunctive relief. It isn't clear to me, however, that there is a transfer of that authority, and that's part of the reason why we're here today.
You think that the arbitrator and the courts have simultaneous authority to provide injunctive relief?
Well,
that would seem really odd.
Not at the outset, I wouldn't think so.
Right.
But
not at the outset.
Once the court has ordered the injunctive relief, my only point is I don't understand where there's a transfer of that particular injunctive relief to the arbitrator with respect to the arbitrator's authority to then lift that injunctive relief.
And no effort has been made to go to the arbitrator to say there should be no provisional, it's provisional remedies is the language that the language gives, right? I mean, the statute says after an arbitrator is appointed and is authorized and able to act, the arbitrator may issue such orders for provisional remedies, right? And it section A, this is 164408, says before the arbitrator is appointed and is authorized and able to act, the court may enter an order for provisional remedies. Right. I mean, why shouldn't we just interpret that to say, as soon as the arbitrator is appointed and the parties are in active arbitration, the provisional remedies of the court are terminated, yeah. Right? You go to the arbitrator.
Right. I would agree that that's a reasonable interpretation.
But you haven't made that argument.
I haven't made that argument, and I just don't, I didn't feel I had the authority to support that argument from the reading that you just did. But I think it would be a reasonable interpretation of the court.
Setting aside, I mean, it seems like, you know, if you want to get rid of this preliminary injunction, balls in your court.
Yeah.
You've chosen to pursue this appeal. Ms. Hollingsworth-Baker has also told us that she's no longer the International Grand Basileus. So,
Right.
so again, my question is why are we here?
So on the issue of mootness, she is no longer the president. She is, however, still a member of the International Sorority. She certainly could be reelected into office. And she's, as a member of the sorority, certainly still subject to potential discipline, although I think it would be unlikely. It's still a possibility. And so, you know, under those, although remote possibilities, I still think that the injunctive relief is the issue of the injunction is not moot.
Is the idea that because Ms. Hollingsworth-Baker is still theoretically subject to the possibility of future discipline from the sorority board, notwithstanding that she is no longer an officer? Is that the only reason why the preliminary injunction has any sort of continuing effect?
Yes, that would be my argument, that she is still potentially subject to discipline, that the board's authority therefore
And the
is
board is
still
precluded from imposing that discipline by the preliminary injunction.
correct.
And that's the only reason that the preliminary injunction is now not in effect superseded by events.
Yes, Your Honor.
Has there been any thought to going back to the trial court, bringing this fact to the court's attention and asking the court to lift the preliminary injunctions? I take it there's no proceedings going on to discipline.
No, there's no proceedings. There's an arbitration. The arbitration hearing is scheduled for January. There have been.
What's the issue in the arbitration proceeding now that she's no longer an officer?
Well, for the arbitration itself, the merits of that proceeding is the issue of whether or not the board had the authority in the first place to suspend her under the rules in the governing documents.
And why does that matter anymore?
Well, that's one, I argued that actually in a motion for summary judgment, that it didn't matter anymore. And that I argued that that particular point was moot and that the case should be dismissed, but the arbitrator did not rule on that and has scheduled it for hearing.
So that's still pending.
That's still pending.
I mean, it just seems like the possibility that she could seek office again and then get disciplined again is both entirely speculative and two is totally unconnected to the complaint, right? I mean, the preliminary injunction is issued based on an assessment of factors, one of which is her likelihood of success on her complaint. And her complaint is all about things that are over and done with, right?
Right.
She wants a declaratory in judgment, or she wanted a declaratory in judgment that the special boule in August of 2020,
Yeah, August
2021? 2021 was legitimate, that the measures passed at that meeting were binding, that the board took unlawful actions against her, that the board can't issue cease and desist letters. Right? All of this is over with.
That's right. But the court went beyond what was being asked, and it actually went beyond what the sorority itself had said was its proper authority, and that's with respect to the board's ultimate authority to take disciplinary action against an officer.
You're talking about the language in the preliminary injunction that the board can't take further action against her without approval of the membership.
Right.
So now we're getting into the merits, but
yes.
First of all, I think that was in Ms. Hollingsworth-Baker's sample order to the court. So I think she asked for that language and she got it. But I mean, second of all, that's getting to the merits, which is away from mootness. We can move to the merits. I guess you just said something about, well, you haven't challenged the issuance of the preliminary injunction, right? Like your brief does not have any analysis of the factors that one would consider to determine whether a preliminary injunction has properly been issued, right?
Right. I'm simply arguing the narrow.
So you are conceding that the court could issue a preliminary injunction?
Yes, I'm conceding that the court had the authority to issue the injunction in the first place. My argument is simply narrowly that they the order itself was overly broad and was not supported by the arguments that were made.
In this limited respect of, it said that the board can't take further action against her without approval of the membership.
Correct.
Because you think the board can terminate her without the membership's approval.
That's correct. That's contained within the.
But that seems to be tied back into the likelihood of success, where she was saying, look, there's a special boule where the membership said, leave her alone. And you have to, under the bylaws, follow the board under the bylaws has to follow the votes of the membership.
Right.
So that seems to be tied into an assessment of the likelihood of success. And you're conceding that the court assessed the likelihood of success and the prejudice and properly granted a preliminary injunction. So I'm confused.
There was no the sorority never agreed that the board could not take action against the president with respect to terminating her as president. That was never part of the boule. There was never a motion that passed that stated that the board had to, as you put it, leave her alone. In fact, that motion was raised and it was
according to Ms. Hollingsworth-Baker, they voted to instruct the board to immediately reinstate all of her rights, privileges, and responsibilities as outlined in the Constitution.
Right, that's accurate.
Okay. So,
but they did not,
why isn't it, given that, there's this months-long back and forth where they're trying to suspend her and she says you don't have the power to do that, and then she has the special boule and they say you don't have the power to hold this meeting, and then the membership votes and they say we don't recognize that vote, and then they try to punish her for showing up at the special boule, and there's all this back and forth. Why can't the court, in its equitable powers, just say, you guys are going to arbitration. I have authority under 164408 to issue provisional remedies. Stop. Status quo. Leave her alone. Go to arbitration. Why you've cited 0 cases to tell us why that is improper. Why in a case where it's proper to issue a preliminary injunction, it is improper for the court to say, I want the status quo, go to arbitration, and then duke it out there, figure out what you're going to do in that context.
Yeah,
why is that wrong? Why is that an abuse of discretion? It's not just wrong, it's an abuse of discretion. It's not even reasonable minds could not agree on that.
Only on the narrow issue of the leave her alone piece. That is
setup of my question.
Yeah, that's
What authority do you have for us to say that that is an abuse of discretion?
Well,
I didn't see any in your brief.
Well, I think the court has to rely reasonably on the record to support their order, and the record is clear that the board retained authority to apply discipline to include removing the president from office.
Except that there's a special boule where the membership says reinstate her.
But that didn't happen. There was reinstatement. I'm sorry, Your Honor. Reinstatement did happen, but
and I understand the board contested the vote of the special boule. But I'm saying, given all of these facts and the back and forth and the each side saying they can't do that, and there's an arbitration clause, and the court has power under the statute to issue provisional remedies until this goes to arbitration, why can't the court just say status quo, leave her alone, go to arbitration? And then you go to arbitration and you figure out what the provisional remedies should or shouldn't be there, or what, you know, your powers or her powers are there, or what the validity of the special boule, or, you know, how these provisions of the bylaws and the Constitution interact.
I totally agree with you up to the point of leave her alone. And you know, there's a distinction between reinstating her, which was part of the special boule.
What is the point of reinstating her if the next day they can terminate her?
Well,
I mean, that would seem to be not terribly compliant with the special boule, which I understand.
but the special
You
boule-
disagree that the special boule was valid. She has a right to go and get provisional remedies from the trial court prior to arbitration. And you are not challenging the trial court's ability to issue a preliminary injunction. You just want a preliminary injunction that doesn't really give her any protection whatsoever. And that seems odd. And I haven't heard any cases that support that understanding of what an empty provisional remedy is satisfactory under the statute.
Well, I would argue that it's not empty. The special boule did, that's basically a meeting where the membership comes together. And at that point, they have the authority to say to the board, reinstate her. The board reinstated her. The issue of leave her alone, you know, not to your point, let's say terminate her the next day. That motion never passed at the special boule, and there's no authority for the court to go beyond what the governing documents say and overly restrict the board's authority to take disciplinary action. You know, you're right. They could have the next day removed her from office, which was provided for part of their authority in the governing documents. But I think I think it was abuse of discretion for the court to, on its own, issue an order to stop the board from exercising the rights that it had under the governing documents of the sorority.
Thank you.
Thank you, Your Honor.
Okay, we'll give you a couple of minutes in rebuttal. Let us hear from Mr. Redden.
Good morning, honors. May it please the court. My name is Kevin Redden on behalf of appellee Valerie Hollingsworth-Baker. The honors, the injunction at issue in this appeal was entered after numerous instances of constitutional violations by the International Executive Board of Zeta Phi Beta Sorority.
Mr. Redden, I'm going to start in the same place and ask you why we are here.
Your Honor, I do not believe that we should be here. I believe this issue.
And yet you have the benefit of a preliminary injunction that's still alive. And we got a filing yesterday at 4:55 telling us you think this is moot. So
Yes, Your Honor.
Is there something else that could be done to resolve this matter short of us hearing this case?
In terms of the narrow issue of the injunction? Your Honor.
Yes.
I believe that it could be taken to arbitration, to the arbitrator itself. The trial court advising, the trial court and the arbitrator that my client is no longer president of the sorority, that the International Executive Board has had significant turnover as a result of the July 24th, 2022 election.
Your client is still seeking relief in arbitration.
That's correct, Your Honor.
Related to this complaint that she filed in Superior Court?
That's correct, Your Honor. Related to the violations of the sorority's constitution by the then International Executive Board, which precluded her for a significant amount of time from exercising her authority as duly elected president of the sorority.
I mean, presumably the same mootness rules would apply here as in arbitration, or maybe I'm mistaken about that.
Your Honor,
Is that the reason why you don't want to tell us it's moot, that because you don't want to moot out the arbitration?
that is not my position at this point, Your Honor. as counsel stated, the appellants made that argument in a motion for summary judgment to the arbitrator. The arbitrator denied that.
And what
motion.
was your client's position in response? If you can say.
I believe that it was, forgive me if I don't state it adequately, but I believe that it was because the harm was because the harm was over such an extent of time and cost my client a significant amount of fees and costs, and including to an abdication of her power for several months. Under the terms of the Constitution, my client was entitled to a directive and fees and costs associated with this issue, Your Honor.
Let me see.
And again, just touching on mootness, just briefly, just like as I stated in the statement filed yesterday, this already had elections in July of 2022. There's a new president, a new international executive board. Because my client's term has expired, the issue on appeal as to the scope of this injunction and whether or not the National Executive Board can impose further discipline on my client as president is moot.
I'm not sure I understand why you say that. If I understood Mr. Floyd correctly,
Yes, Your Honor.
absent the injunction, the board would still have the perhaps theoretical, but the power to further discipline Ms. Hollingsworth-Baker. And the injunction precludes the board, if I understood the counsel correctly, the injunction precludes the board from doing that. I assume that it's in your client's interest to have that judgment, to have that obstacle to further discipline in effect, to continue in effect. So why is this appeal moot from your client's perspective?
And yes, Your Honor, the appeal is moot from my client's perspective for several reasons. The injunction was requested in the context of the board's actions against my client in her official capacity as president. The order itself, I believe at record page 1346 states that my client has the continued interest in pursuing re-election and leadership, and that's part of the harm that would come to my client had the injunction not included the language precluding them from further harming her. Now that this has happened, any further discipline would occur at either the chapter level or if the International Executive Board or the International Grand Basilius. And if you look at the delegation of authority matrix, which is at record page 126 and 127, the International Grand Basilius has the vast majority of the authority to apply discipline to members and chapters. The IEB can only expel members, and presumably that's founded in the language in Article 5 of the Constitution, which allows for removal of International Grand Basilius. Now, because of the fact that the injunction was entered in the context of the actions of the board against my client as president, the fact that my client is no longer president, and the fact that the order states specifically that my client was seeking to be reinstated to a position in accordance with the vote at the special boule and seek re-election. The injunction itself, as we believe is moot, Your Honor.
Is what?
Is moot, Your Honor. So any further discipline would come at the chapter level or in accordance with the procedures of the Constitution.
Well, I suppose that if Mr. Floyd agreed with you that there was no concern about future discipline. But I thought his whole point was that is what the injunction is preventing the international board from imposing. And you may have an argument that, well, they're not allowed to impose it. But that argument that they're not allowed to impose it doesn't make the injunction moot. The whole point of the injunction is that's right, they're not allowed to impose it. I don't understand. I don't understand why. I mean, if you're saying it's moot, you're saying you don't care if the injunction is lifted.
In terms of The injunction in terms of the appeal on issue today, the scope of it,
Excuse me?
in terms of the scope of the injunction, in terms of further.
Much of it is moot.
Right,
She's no longer the president.
right, correct, yes. Your Honor.
Right. But there's, what I'm asking you is, there's a portion of it, according to Mr. Floyd, that's not moot. And it might be theoretical, maybe the board doesn't really want to
Right.
discipline her anymore, but their past history is they don't like her. And they might want to discipline her. So I'm having a little trouble understanding why I'm repeating myself, I don't mean to, but I don't understand your answer. I mean, it could well be the case that you would have defenses if they tried to discipline her. You would say, well, you can't do it, only the chapter can do it, or whatever. Well, that's very nice, but that doesn't make the injunction moot. It just means you might not need it if they end up agreeing with you. And similarly, I don't understand. I mean, if I was the arbitrator, I'd certainly think twice before I, and then twice again, before I could say, well, you don't have to worry about that court order. I'm superseding it. I think the way you supersede a court order is going back to the court. I'd be surprised to hear that the arbitrator could override it. So I'm having a little trouble understanding why you think it is moot. I would have thought you would say you want us to affirm the judge's injunction. But I don't hear you making that argument.
Yes, Your Honor. So I'll get to the merits of interest in a moment, but in terms of, again, the issue of the precluding further harm, that this order was entered again in the context of the unconstitutional actions of the National Executive Board. And as Your Honor stated earlier, it is very likely at that point that the International Executive Board would turn around immediately and then attempted to exercise its authority to remove my client from her position. That is no longer at issue because my.
So what ruling do you want us to make on appeal?
On appeal, we would request that the injunction be affirmed with the understanding that our client, there's been a significant turnover in the makeup of the International Executive Board, and that there's a new president for the sorority. That at the time, the injunction was proper, given the context of the situation.
So that's different from our saying the injunction is moot.
Yes, Your Honor.
If we were to say the injunction is moot, we would say presumably it's no longer in effect.
Yes, Your Honor. I understood. And I think that gets to the merits of it a little bit, which is the trial court didn't abuse its discretion at the time because the record supports the scope of the injunction, right? The record reflects that the board methodically and repeatedly attempted to remove my client from her position as president, and did so via violations of the Constitution in numerous ways. The first of the violations was my client's suspension. Article 5, as I stated earlier, of the Constitution enables the board to remove my client for misfeasance and malfeasance. However, the Constitution limits the ability of the International Executive Board to impose a suspension. They can only recommend a suspension, and that's found in Article 15, Section 2B, and that can be record page 106. What happened here is that the board failed to remove my client on March 28th, 2021, and instead they attempted to do the next best thing, which was suspend my client and revoke her privileges for the remainder of her term. The Constitution just simply prohibits this from happening, and the limitations were confirmed in two separate reports. One created by McFadden Davis, who the appellants hired to investigate my client. In a note, footnote 2 on page 497 of the record, they state that the board can only recommend suspension and cannot impose it. They then state that the president would have to impose a suspension on herself. The second was a report done by Parliamentary Associates, and that can be found at page 190 through 204. The Parliamentary Associates found, quote, that forms of discipline, including as outlined in the disciplinary actions set forth on May 13th, 2021, the suspension of my client, are not within the authority granted to the board for disciplinary action and appear to be an overreach of authority. The board also sent multiple cease and desist letters, both to my client and to individual chapters of the sorority. An example at page 470 to 471, there's a letter to Mu Zeta threatening disciplinary action for participation in the August 28th, 2021 special boule. And of note, the ability to enforce financial discipline is only given to the IGB, and that can be found again, I'm sorry, the International Grand Basilius, and that can be found again in the delegation authority matrix. The cease and desist letters to my client were sent on August 13th, 2021 in direct, which is a direct result of her efforts to organize and plan the special boule. And there's another one sent on September 10th, 2021. And importantly, that was sent after the membership voted to reinstate my client to her position as president. So any authority that the board had or claimed to have had at that time was extinguished after a due vote of the membership who formed a quorum at the August 28th, 2021 special boule.
So I'm just looking at the trial court's order and its analysis of the likelihood of success on the merits. And its analysis is much more abridged than yours, right? It seems to focus on one, that the special boule was a valid meeting, and saying that, you know, they voted to reinstate her and that's binding. And then talks about the limitation on the board's authority, and that it can't suspend privileges. So all this, you know, these extra facts about cease and desist letters and all of this stuff, that the court didn't seem to focus on that in assessing likelihood of success on the merits. Do you want to just focus on what the court said and tell us why that supports the scope of the injunction that was issued?
Yes, Your Honor, and just briefly, I believe on page 1343, the trial court did discuss sending cease and desist letters to the membership.
I don't doubt that it's in the facts. I'm just saying when the court is analyzing the likelihood of success on the merits, which presumably is sort of the foundation for the injunctive relief that is then granted, the court is not talking about that.
Right. Yes, Your Honor. So I think it comes back to what we discussed earlier, which is the special boule was duly authorized by 33 chapters. There was a vote at the special boule to reinstate my client in her full capacity as president. The International Executive Board disclaimed the legitimacy of that special boule. They then ignored the will of the membership, expressly ignored the will of the membership, and refused to instate my client. In fact, she was only reinstated upon the entry of this injunction 5 months after that vote. The special boule itself was legitimate, and there's no reason why the vote should not have been honored by the board. And just briefly, I know that, you know, when there was a quorum present, and under DC Code 29401.50 D8, quote, if a quorum is present when a vote is taken, the affirmative vote of a majority of the votes cast is the act of the board of directors unless a greater vote is required. So at that point, once that vote was taken, that was the act of the board, and my client should have been reinstated. The trial judge acknowledged the appellants would stop absent the injunction and properly exercise her discretion to reinstate my client and preclude further harm to my client as a result of the appellant's actions. Thank you.
Thank you. Mr. Floyd, we'll give you a couple of minutes in rebuttal.
Mr. Floyd, I do want to note, we're in the curious position here where it sounds like you have opposing counsel agreeing that the preliminary injunction could be lifted, and it seems like both parties could go back to the Superior Court and make that request. Nonetheless, we are here, so I will hear what you have to say on rebuttal.
Right. Thank you, Your Honor. I certainly wouldn't object, and I thought that's maybe where we were headed, but I think we're still a little bit hung up on just this very narrow issue, and it's.
Well, I don't know that it would be a narrow issue if you went back to the Superior Court and said you can lift the injunction now. So.
Right, and I'm a little concerned about the authority of the arbitrator taking this up. And so I would like some direction from either this court or the Superior Court on that issue. And it's
There's no issue if the Superior Court lifts the injunction upon the request of the parties.
correct, if the parties could agree on that.
Right.
We could leave here today without that, not come to that agreement. But I just want to make the point that at the boule, whether the boule was authorized or not, and that's certainly something that's going to be subject to the merits arguments that are made before the arbitrator. There was no decision by the body at the boule that quote further harm could not be imposed upon, and I'm putting further harm in quotes because that's not, you know, I'm simply talking about further discipline. Whether that constitutes harm or not that's a different question. But there was no ruling or motion or approval by the body of membership at the boule that would have permitted or restricted the board's authority to take action that
I
was.
take your point that literally there was not, right? I mean, you know, based on the limited record that we have, right? We're here on a preliminary injunction and all we have is the representation. I don't even think that we have some formal documentation of what the vote was, but we have the uncontested representation that the special boule voted that the International Executive Board be instructed to immediately reinstate all rights, privileges, and responsibilities as outlined in the Constitution and bylaws and other governing documents related to the position of the International Grand Basileus, right?
That's correct.
That is the
And I'm not
language,
arguing
right?
that.
You don't argue with that,
Right.
but it seems strongly implied that if you were saying reinstate this person, that you were also saying let this person do their job, which would seem to be inconsistent with subsequently limiting this person's authority or terminating them, right? So I take your point that there was not a second vote on leave her alone, but it, like I said, seems strongly implied that that is what the special boule was voting for.
And there would have been no authority for that vote, and it would not have passed because the governing documents are very clear that the authority for the board, at least for removal of the president, rests with the board. And I would agree. I mean, you know, maybe it could be implied that, you know, when she came back, we're saying to the board, leave her alone. But on the flip side of that, if the president went out on a flyer and now felt that she had authority to do anything she wanted, and the board was now tied, her hands are tied with respect to applying discipline to protect their sorority, that there's just no authority for the court to give the appellee that sort of vast.
But it's a giving authority in a particular context, which is pre-arbitration, right? And so I think sort of assessing whether the court was abusing its discretion in that context, and I still have, you know, I didn't see it in your brief and I haven't heard it from you at the podium, any sort of authority to say, you know, this is an abuse of discretion in this context.
Other than I haven't given you case law authority, but the governing documents, the court, I think, is bound by the governing documents that are at issue in the lawsuit, as well as the arbitration, and was at issue with the before the court in the injunction. And those governing documents are very clear. And in fact, the appellees concede that the board did retain restriction, or did retain authority to remove the president of the sorority. Thank you, Your Honors.
Okay. Counsel, thank you both. Case is submitted. We'll call the third case on the calendar. Unit Owners Association of 2337 Champlain Street Condominium versus 2337 Champlain Street LLC.
May it please the court, Louise Gacheva for the appellants, the Unit Owners Association of 2337 Champlain Street.
I'm going to ask you if you can to keep your voice up.
Oh, I'm sorry. I'm very soft-spoken and I have issues in courtrooms. I apologize. Donald Mullican, Pedro Cawley, Sharon Cow, and Bianca and Luis Liu. Your Honor, if I may, I'd like to reserve 5 minutes for rebuttal.
Mhm.
The issue before the court today is the determination as to whether the DC Condominium Act allows a wholly unrelated entity to the association, in this case, the Erie, to exercise an absolute veto over the will of the unit owners of an association in perpetuity. It cannot, under both the statutory scheme of the District of Columbia and the relevant case law from this court and from other courts. There are sort of two buckets of arguments in our appeals. The first deals with the amended bylaws and whether or not they're void. The second deals with this issue that was raised in the court's omnibus order as to whether the constructive notice was sufficient to absolve what we've referred to as the developer entities. And that's 2337 Champlain LLC and Capital City Real Estate of the misrepresentations and the misleading statements that they made to the appellants. First, I would like to deal with the issue of the amended bylaws. The amended bylaws were unilaterally adopted by the declarant and purported to allow a neighboring condominium, the Erie, to exercise an absolute veto over any changes made to a section of those bylaws. There were specific restrictions put in place that were solely for the benefit of the Erie and had no benefit to Champlain or its unit owners. These restrictions are not valid because they violate DC Code 42-1902.27B, which is the Amendment of Instruments statute that allows a 2/3 vote of the owners to amend the bylaws. It also violates the public policy that undermines the entire Condominium Act and subverts the association's ability to self-govern. Thirdly, the amended bylaws themselves are unreasonable. And fourthly, there is no easement. The amended bylaws do not constitute an easement and therefore they are improper.
What if they did? I mean, what if not if the bylaws did constitute an easement? What if the second settlement agreement created an easement?
Under this court's holding in OC and under the statutory scheme, an association, the board does have the authority to grant an easement.
But what if, right? I mean, easements run with the land,
They do.
right? And what if the developer, gets sued by the neighboring property and to settle that lawsuit says, look, we'll give you an easement of view, right?
Yes.
We will keep the, this level of the building free and clear for your visual enjoyment, forever, and there's consideration and it's all documented and it's even written up in a document that says, we're settling and we're giving you an easement. Where then what happens with your bylaws arguments?
Well, that's the granting of an easement is specifically contemplated by the statute. So that's a proper exercise because at that point, the declarant's operating as the association. But the amended bylaws are a separate document.
Right, but I understand, but so assume in my hypothetical that everyone acknowledges that there's an easement and then the bylaws are amended to say, and hey, we're going to give the neighboring property, a say in anything we do with respect to the top of the building to protect their recognized uncontested easement.
They would still be invalid because the rights of the Erie would be protected by whatever was in the easement. So to the extent anything was added into the bylaws, those would still be invalid because it would still subvert the statutory provision that allows the amendment. There's no restriction on the amendment of bylaws within the DC Condominium Act, other than it must be by a 2/3 vote of unit owners. So the amended bylaws would be void, they'd be unenforceable. The same argument we have here, the easement would be enforceable under the traditional easement statutes.
I'd like to press you on this argument that the restriction, well, it's really two things. It's the grant to Erie of what you've called a veto. And it's the restriction on the members, preventing them from amending the bylaws to remove that veto provision. And all that's in the bylaws,
Yes.
the amended bylaws, which the developers could adopt when they did. Set that out pretty clearly. So the issue, I think, is one of statutory interpretation. Is it really true that 42-1902.27b precludes that? And I'm not sure that I see a clear preclusion in the statute. It does say that the condominium instruments may be amended only by agreement of unit owners of units to which 2/3 of the votes in the unit owners association pertain. In other
Yes.
words, simply put, you need put any amendment requires a 2/3 vote of the unit owners.
Yes.
So that's a necessary condition. But it's not clear to me that that means it's always a sufficient condition. It's not clear to me that the bylaws can say, okay, not only do you need a 2/3 vote to make a certain type of change, but you also need something else, some other condition has to be met. And I don't really see anything in the statute that forbids that. Indeed, some sections of the statute, I think, like subsection G, indicate that there can be other conditions that have to be met at times. So while it may be unusual, it may be unwise to have an agreement that allows a neighboring to have bylaws that allow a neighboring association to have a say in certain types of decisions, to veto them and to require their consent. I don't know that there's anything in the law that actually can be said to prohibit it.
Your Honor,
And that's what
think-
I'd like you to focus on.
Certainly, Your Honor. I think if we're doing this under a statutory construction rubric, then we're looking at the plain language of the statute, which without limitation says 2/3 vote of an owner can amend the documents, period. So that by looking at that and reasonably reviewing that section, there is no limitation on that, because then if you start reading into
Well, it says it can be amended only by
correct,
a 2/3 vote.
yes.
So that tells me, well, a 2/3 vote is a minimum requirement. But if the bylaws themselves want to say, well, not only do you have to have a 2/3 vote, but also an additional condition sometimes has to be met, I'm not sure that the statute precludes that.
Well, Your Honor, I think we disagree with your reading of the statute, if I may. It specifically says the condominium instruments shall be amended only by agreement of unit owners of units to which 2/3 of the votes in unit owners association pertain, or any larger majority that the condominium instruments may specify, except in cases where this chapter provides different methods of amendment. If you read that section, the plain meaning of that means this is how you amend documents, a 2/3 vote, or the documents can specify a larger majority, or also there are some exceptions in here for different types of changes, none of which apply in this case. If you're just looking at that language, that is 2/3 vote can amend the bylaws, because if you take the converse of that, what Your Honor is arguing, I think Your Honor made the statement that it's perhaps unwise. Well, Your Honor, you could have a declarant imposing all sorts of restrictions in bylaws that cannot be amended by the unit owners. It completely undermines the purpose of the Condominium Act and the condominium. The purpose of the condominium structure is the unit owners are giving up some freedom of choice to the association that they vote for and that they have control over. They are not agreeing to give over any control to a wholly unrelated third-party entity and be bound in perpetuity. If the court finds that this restriction is valid, that means 100 years from now, the association, to the extent it still exists, will still have obligations to its neighbor, the Erie, that they can't do anything about. And that undermines, that flies in the face of the language of the statute, and it undermines the entire purpose of the condominium scheme itself, which you give up some rights, but you give up some rights because you're going to vote with your collective unit owners.
Well, suppose there had been an easement
And
granted in the form, in the way in which you would like to see it granted. Wouldn't that have the same effect?
It would have the same effect, but an easement is a different scenario. That is specifically contemplated by the statutes as something that the board has the authority to grant. And there's a reason for that, because an easement, it runs with the land. Is similarly the second settlement agreement in this case, which
Why shouldn't we view this as incorporating in the bylaws an easement?
Because it's not an easement. It doesn't have the indicia of an easement. If you look at the case law,
I agree that the provision it doesn't look like an easement, but it basically is there to enforce an easement. It recognizes the existence of an easement, and it says this recognition shall not be amended without, or the terms of the easement shall not, in effect, shall not be changed without Erie's approval.
But
that doesn't, it could be argued, I think, maybe it could be argued both ways, but it could be argued that doesn't do anything more than just having an easement would do.
Your Honor's hypothetical assumes that there is an easement in existence, which there is not in this case. And that further goes to the issue of the Erie never claimed there was an easement until their appellee brief. In the trial court, they claimed they were a third-party beneficiary.
But when you say there's no easement in this case, are you saying that the Morgan condominium could just ignore all those agreements about the restrictions on the roof and just do what it wants?
Yes, they're void in the amended bylaws, and the trial court already found that the second settlement agreement did not bind the association.
Yes, I know. So you're saying that the only thing that stops the Morgan condominium from doing away with the green wall and doing away with all those roofing restrictions is the provision in the bylaws?
Yes.
That says you shall not do that without the consent of Erie.
Yes, that is the only provision,
That makes it look like an easement to me.
except for in order to have an easement, you have to have a specification that the obligation is going to run with the land. There is no statement in either the second settlement agreement or the amended bylaws that these obligations run with the land. And the case that's very instructive on this point is the Oddfellows against Carmine's case.
I beg your pardon?
Oddfellows against Carmine's, in which the court found there was an easement, but because in the agreement, it specifically said, quote, that the obligation ran with the land, end quote. And it then also looked at the circumstances surrounding how that easement was treated. There was the initial agreement in which it was specified that it ran with the land and would be binding on future owners. Second, that there was a second agreement in which that
To say
language.
it's binding on future owners
Yes,
is to say the future owners can't change it
correct.
without the consent of the party who's eased.
Yes,
And that's what this provision does. Now, it doesn't say in words in haec verba, run with the land,
correct.
but why is that so essential?
Because the case law has stated that that is in order to create an easement where you don't have a deed, like the traditional format, that you have to have 4 items present in the easement. Identify the dominant and servient estates. I think arguably they probably met that here. State the purpose of the easement's general location, and specify that the obligation runs with the land. They definitely have not met number 4. I would argue that number 3, the description is sufficiently vague as to not be enforceable as an easement. And number 2, they state is for the benefit of the Erie. That probably is sufficient, but that is what
I
is
don't know.
necessary.
I'm
to create an
looking at
easement.
this settlement agreement. This is attached to the complaint. So I'm on page 3 of the settlement agreement. And it's talking about maintaining the view and keeping the roof space clear. I mean, the building is, you know, the dimensions that it is, the roof is what it is, that seems reasonably specific. You know, your point about running with the land, I mean, do we say that in Board of Trustees in the Oddfellows case that you have to have all 4? Was it set
Yes,
out as a criteria, like checklist?
yes, Your Honor, there was a checklist.
I
of
mean, we
items,
say
and I-
no particular words of art are necessary to create an express easement. So you don't have to call it an easement. I'm looking for the checklist. I mean, certainly in that case, the agreement did say it ran with the land.
Correct. I will. I believe it's 745, Your Honor, is the page site. And I may have misspoke. I think it has to specify that the obligation runs with the land. But I mean, the easiest way to say that would be that it ran with the land.
Yeah, I'm not seeing where we say if it doesn't say it runs with the land, it fails.
I apologize, Your Honor, I don't have the actual case in front of me, but I believe it is at page site 745, and that it specifies that in order to create an easement, that these 4 sort of factors would have to be present. They may not be enumerated. Therefore, Your Honors, we'd ask that because there is no easement in this case, and also because this issue was never brought up in front of the trial court, that the court find that the amended bylaws are void and enter judgment in favor of the association. Thank you very much. If the court has no further questions.
Okay, thank you. We'll give you a couple minutes in rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Tom McGavro. I am here on behalf of Erie Condominium. I would like to split my time, if I may, with my co-counsel. Turning to Judge Easley, turning to your last question, the court did not say in the Oddfellows case that there was a checklist that had to be met. In fact, what the court said at 744 was an express easement may be created through a contract or conveyance. There are no particular words of art necessary to create an easement by express grant. And what it said on 745, to the extent the trial court thought that greater specificity of language than what was presented in that case was required to create an express easement, it was mistaken.
But in that case, they did say, I mean, I think they actually, the parties at earlier points in time had called it an easement and had said that it ran with the land, right? So that language was present. I'm curious, Erie has never sought a declaratory judgment that it has an easement, right?
Erie did not seek a declaratory judgment that it has an easement. It did seek to enforce the settlement agreement and sought an injunction to enforce what is in the bylaws and the settlement agreement. I was not trial counsel. I cannot speak to the decision not to counter appeal, but that issue is not before this court. If I may.
And by that issue,
Whether or not,
the existence or not of an easement is not before this court.
no, whether or not the injunction was properly denied. That issue is not before the court. I think that the trial court did properly find that this constitutes an easement. If I may back up.
Did the trial court find that this was an easement?
I believe it.
I mean, it's
did.
cited to Ox,
It did,
which
Your Honor.
is an easement case, right?
Right.
But
If I may back up just for a couple seconds on the question of running with the land. The bylaws do specifically state that those provisions run with the land. That would include the provisions regarding restrictions on the rooftop use. So to the contract, the settlement agreement itself, and I'd have to go back and look, I apologize, may not have said this runs with the land, but it did say that the bylaws would be amended to reflect the settlement agreement, and the bylaws specifically state that they do in fact run with the land.
What provision of the bylaws is that? Can you tell me?
I would have to, I don't have it off the top of my head, Your Honor. I'd have to look at it.
Okay, well, I just wondered if you had it.
It is in there. I know we cited it in our brief. I just don't have that right here. Again, to return to Your Honor's question about the trial court definitely relied on Ox and found that the amended bylaws constitute an easement. Did the trial court use that explicit language?
I mean, I don't know that I see easement in the trial court's order other than in the parenthetical describing the holding of Ox.
Right. Nonetheless, Your Honor, I think the trial court did conclude that the bylaws properly allowed for an easement of view over the roof of the Champlain, the Morgan.
I have a few questions about the bylaws, but before I ask you that, how do you respond to, well, your opponent makes the point that you first raised the concept of an easement on appeal.
Yes.
What significance do you think that has? The failure to raise it in the trial court?
In this case, none, Your Honor. Because this court obviously can affirm for any reason not relied upon by the parties or by the trial court, as long as, and the case that appellant cited, as long as the issue was in fact before the trial court. So.
And no procedural unfairness.
And there's no procedural unfairness. The information before this court and the arguments before this court were the ones presented to the trial court. We did not focus on the easement question, but we did focus on.
Well, you see, I have wondered a little, this hasn't really been explored, but I've wondered a little whether it's really true to say that the language of the bylaws that we're fussing over is really equivalent to an easement. Because it's one thing to say there's going to be an easement for the benefit of the neighboring building. They have certain rights. Okay, it's another thing to say that any amendment touching on that whole area is going to have to be run by any amendment to the bylaws. Touching on that whole area is going to have to be run by that other party. It's not clear to me that that doesn't go beyond simply recognizing and binding the condominium unit association to an easement. It would have been better, in other words, and maybe more and maybe narrower, to simply have a document or court declaration recognizing a specific easement without injecting without in effect injecting Erie into the governance of the association.
2 points on that. if I may, first, it doesn't inject Erie into the governance of the association. It injects Erie into the treatment of the roof. Those are the only provisions that Erie has any kind of say in. They can do whatever they want with the rest of the building. They could paint the whole thing pink. Nobody cares. The only thing they need to confer and consult with Erie on is what they put on the roof and how high that stuff may be and whether it blocks Erie's view, which Champlain has granted to Erie. So this whole idea of an absolute veto is, if I may, a bit of pearl clutching. Second of all, the bylaws, the original bylaws that were.
Well, it does give them a veto over some decisions.
It does.
They have to exercise it reasonably,
Right.
but in the end, it can be a veto.
Yes, and that was my second point. Actually, the original bylaws, the ones that were recorded in 2015, state that Erie, with the first settlement agreement, states that Erie has the right to veto.
May I ask you about that?
Yes.
There seems to be, I may be mistaken about this, so if I am, correct me. But when I look at the provision of the original bylaws, there's some language missing. And the key words seem to be missing. Now, maybe they were put in somewhere or corrected or what have you. And
Well,
tell me about that.
well, the original, as the court knows, there were two settlement agreements. The developer wanted to build the building. Erie objected. I'm running out of time and I apologize. Erie objected. They reached a settlement agreement and the first set of bylaws were recorded. Those first set of bylaws, Judge, you're absolutely correct. Those first set of bylaws said Erie's got the right to veto. That was 2015.
Except that that right is not clearly set forth in there because the language seems to be missing.
Well, the original bylaws do say Erie has the right to object, or this shall be done with the consent of Erie, something like that. After the second settlement agreement, after they got into an argument again, Champlain, the developer, amended the bylaws, and at that point added additional language to the amended bylaws, and gave Erie the right to object as long as that right was reasonably exercised, as long as Erie decided and reasonably decided that such amendment would affect its right of view over the roof. Which means the first amendment to the bylaws actually narrowed.
Well, let me, this may be important enough that I want to press you a little bit on it with the specific language. What I happen to have handy, and this may not be the most authoritative source, is your brief.
Actually, that
Well,
is.
actually, it's Pardo and Dre.
It's Champlain's brief, yes, Your Honor.
It's the developer's brief.
Yes, Your Honor.
And it compares the provisions of the original condominium bylaws on page 20, if you have that handy,
I do.
with
Your
the
Honor.
First Amendment. Now, if you look at the paragraph of the original bylaws, it says this provision, it's the second sentence, this provision is for the benefit Erie Condominium Association located at so-and-so, Washington, D.C., without its express written consent. But as written, that doesn't clearly require certainly the association to obtain written consent of Erie. Words have been left out.
That is.
Namely,
that is
the words, what they should have said is, this provision is for the benefit of Erie and shall not be modified
If I may, Your Honor,
in any manner without.
the
And
appendix.
those words are left out, but are you
Right.
telling me that the correct document?
Right, if you look at the appendix at page 443, the provision does in fact say and may not be modified in any manner without the express written consent of the Erie Association.
Okay, so that is actually in the original.
That is, it was simply, it's not in the brief excerpt, the excerpt in the brief. I'd like to raise one other point, if I may, before I sit down, and that is that these amendment, the first amendment was in fact recorded in August of 2016. Suit wasn't brought until August of 2018. I wanted to make sure I mentioned that. I'm sorry, Your Honor, did I address your points?
I think so, yes.
All right. If that case, I will yield to my colleague. Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. Russell Drazen for 2337 Champlain Street and Capital City Real Estate. Your Honors, the developer defendants were entitled to summary judgment on counts 3, 4, and 5 of the complaint for 5 reasons. First of all, the sales contracts between the individual plaintiffs and the declarant included a 1-year contractual statute of limitations on all claims. Contract claims, tort claims, statutory claims, and it applied to all parties, the individual plaintiffs, the plaintiff association, the declarant, and the developer.
You know, you're touching on something that interested me. The trial court, I mean, we're reviewing a grant of summary judgment. The trial court granted summary judgment on this 1-year limitations ground, paragraph 22 of the purchase agreements, only with respect to the fraud count.
Correct.
And not with respect to the other counts.
Correct.
So it's not clear to me that the judge may have been wrong. I understand the interpretation. She may have interpreted the agreement mistakenly, but I'm not sure that the denial of summary judgment to you on that ground is something we really have to get into here or should get into here. You didn't cross appeal, for example.
I don't think you need to get into it. I think you could affirm
On other, there are other grounds.
on the
that
other
you relied
grounds.
on.
Correct. That's
I realize
correct.
that, and I do have some questions about those.
That's correct. But I think clearly the trial court did make a mistake, and that the cases that we cite, and we cite a number of them, not from this court but from other courts, stand for the proposition that if a contractual limitations period is intended to encompass statutory claims, well, then it also includes, it bars statutory claims. And there was no case law cited to the contrary. And so on that basis alone.
Now,
this-
I can understand your argument that the individual purchasers are bound by paragraph 22, the 1-year time limitation period. I don't think I understand the argument that the association itself is. The association was not a party to any of those purchase agreements.
That's true.
And it's not clear to me that the individual purchasers could bind the association in those agreements. There is a recognition in paragraph 22 at the very end. but
Correct.
It's not clear to me that that has any legal force. Now, a better argument, I think, is the argument you make that the association, not having been a purchaser, has no claim here.
Correct.
That
Right.
I get that.
Which is right. And that eliminates all claims by the association plaintiff altogether because
Against the
associ-
developers.
I'm sorry,
Against the developers.
against the developers, correct, because the association plaintiff was not a purchaser, was not
At least, yeah.
not a consumer, and it wasn't entitled to any public offering statement, correct? So yes, that was our point 5 in our 5 points. I can go through the other.
We've got 2 points under our belt now.
Okay. Point number 3 in my list, it's number 2, and it's that, Your Honor, there were the plaintiffs sued for money damages, sued the developer defendants for money damages, and yet proved no damages in this case, no money damages. We
Yeah,
specifically-
that interested me. If it is correct that the plaintiffs have no money damages, that the purchasers have no money damages, is there any relief that they can, in your view, and I'll be asking counsel for the opposing counsel the same question. Is it your view that there's no other relief that they can seek from the developers?
Correct. And as a matter of fact, they didn't seek any other relief. They didn't sue for an injunction. They sued for violations of statute and for fraud.
On the other hand, why would one say that the plaintiffs have no damages? Their claim is that their use and enjoyment of the rooftop property has been diminished, that diminishment must be worth something. It reduces, at least in theory, conceptually, the value of their property. Why is that? Why would one say they have no, they didn't articulate this as one answer, but why would one say they don't have any damages?
Why would I say that, or why would the
one
plaintiff say that?
conclude they don't have any damages?
Well, they
Therefore,
we specifically
'Cause
asked
you
them at
asked them, they
discovery,
didn't
and they
identify.
specifically said, we reserve, I think they made reference to declaratory relief, which
And
would have
this is
been
a ground on which the trial court did rely.
correct.
Yeah.
That's right, Your Honor. And so, you know, I can't explain why they did that, but they specifically made reference to, we reserve the right to provide appraisal expert with respect to, and this goes to Your Honor's point, which is that it presumably they would somehow try to gin up damages with respect to a diminution in value, but they didn't do it. They did not do it. And so there were no damages in this case. And so with the absence of damages,
So one of the
claim is
grounds you
failed.
moved for summary judgment on was there are no damages.
Correct.
And they did not show a genuine. They did not show a genuine dispute about that particular
Correct.
fact.
That's right. That's right. And then the final 2 points had to do with the what the trial court relied upon, the actual notice of the use restrictions and constructive notice of the use restrictions. The actual notice being the bylaws, the original bylaws that were provided to the individual plaintiffs as part of the public offering statement. And then the constructive notice being the recordation of the bylaw amendment in the land records, which was done before any of the individual plaintiffs settled on their respective condominium units and rooftop cabanas, and the trial court correctly relied upon that in finding that there was no violation of the statutes and no fraud, in as much as it was disclosed. The restrictions on use, even if you assume that the restrictions from the bylaws to the bylaw amendment were material, which we disputed, but even if you assume that, the bylaw amendment was disclosed to the plaintiffs, and so therefore there's no liability, and they couldn't have reasonably relied.
When was the bylaw amendment disclosed to the plaintiffs?
The bylaw amendment was recorded
It was recorded,
in the land records,
But it
and
was
that,
not-
and that
but it was not, it was recorded in the land records only a few days before the closing.
a few days before the first closing, correct?
The first 2 closings.
Right, correct, that's right.
I mean,
I'm not using the word disclosed in the sense that it was handed to them. I'm using the word disclosed in the sense that it was publicly available. It was recorded. It was a public document that was recorded. And we know, based upon the sales contracts, that the individual plaintiffs all settled with a title company. And so they got title searches. Someone, their agent searched the land
But the
records for
title
them.
search doesn't happen day of, does it? I mean,
The title search, a title search would normally happen prior to the day of settlement, but then there would be an update that would be done to ensure that, to make sure that whatever was of record between the date of the original search and the date of settlement, or the date that the deed is recorded, would be disclosed.
what does the record before us show about whether that update was done?
I don't know that there is something in the record about that. I'm making reference to it because there was a case cited by the plaintiffs that they purported to stand for the proposition that the fact that something's recorded doesn't give constructive notice, and this court in that case specifically said, well, wait a second, the purchaser in that case actually did search the land records, and so they would have had constructive notice, because they actually did search the land records. Here, I don't think there's something in the record that I can point to say that they actually did, but I can point to the sales.
It seems rather harsh to say that, because it seems somehow unlikely, based on what we've seen, that there was any last minute check of the land records to see if there had been any changes. Now, there may have been, but I'm unaware of anything in the record that establishes that. And, you know, the notion that they're constructively on notice of changes that were made just very shortly before they sat down at the closing table seems a little unrealistic.
It is the
Excuse
law
me?
of, it is the law of this jurisdiction that matters that are publicly recorded. Everyone has constructive notice of matters that are publicly recorded.
Now-
But I will concede that the argument about constructive and actual notice, that's only if you get past the statute of limitations, the no
I
damages and
understand
the
that. But
plaintiff
let me
association have no
focus
claims.
let me continue with you to focus on this constructive notice argument. The judge did not seem to respond to the unit owner's argument that constructive notice doesn't apply where affirmative misrepresentations have been made by the defendant to the plaintiffs. And I don't know that that any of the briefs on appeal really respond to that argument either. Do you want to speak to that?
I think Your Honor's right. I don't think the briefs do speak to that. But I would say that here, the alleged misrepresentation was the failure to amend the public offering statement to disclose the amended bylaws. So if we're relying upon the constructive notice for knowledge of the disclosure or knowledge of the amended bylaws, well then that vitiates the alleged fraud. We didn't mislead them. We didn't tell them don't bother to. There's no allegation that they were told don't bother to search the land records. You're not going to find anything there. And then meanwhile, there was
It
something
might not be
reported.
fraud. I think their best claim is really the claim of failure to provide information that needed to be disclosed in the public offering statement. And it relates to, I mean, there's two categories of information, I think, and maybe the arguments are different depending on which category we're talking about. One category is the information about the roof restrictions that were imposed as a result of what's been called the second settlement agreement. And then the other category is this provision that they've complained about, is this provision in the bylaws giving Erie a say in whether the bylaws could be amended. And in fact, the very amendment of the bylaws, I suppose. And I wondered whether an argument about constructive knowledge really works if there's a defect in the a non-disclosure in the public offering documents. How do you respond to that?
Your Honor, I think
You're supposed to say certain things. I tell them keep it up to
I-
date and so forth.
I think first of all, you have to first assume that the differences between the bylaws and the bylaw amendment were material, such that they were required to be, such that the public offering statement was required to be amended. And if you make that assumption, then the second part of the analysis about the constructive notice, that is the individual plaintiffs would have received that information prior to their closings. So even if the public offering statement was not amended, they are on constructive notice of the provisions in the bylaw amendment, and therefore they have nothing to complain about. There's no violation of the statute. There's no damages. And indeed here, there was no damages anyway, but then there would be no damages. There's no reasonable reliance. There's no violation of the statute. The failure to disclose was effectively cured by the constructive notice. It would be different if it hadn't been reported.
I mean, it's hard. It seems to me it's odd to think that where a statute says you must give a public offering statement containing certain very specific required information, then if you don't give it, you violated that statute. And it's sort of surprising to me to think that, well, an answer can be, well, but they could have looked it up themselves. They could have, and maybe they should have,
They could have.
but but I'm not sure that means there's no violation of the statute. And this becomes important in a way for the purposes of the Consumer Protection Procedures Act count as well. Because the trial judge said, well, the trial judge granted summary judgment on that count on the basis that, well, there's no violation of the underlying, if you want to call it underlying, there's no violation of the excuse me, of the public offering statement statute. That seems wrong. It seems like there was a violation of the, it may have been cured, it may have been whatever, but although I don't think cured is the right word somehow, but you see what I'm getting at? I'm focusing on the reasoning of the trial judge in granting summary judgment on each of these counts. And some of it I have some difficulties with, and I'm interested in hearing how you respond to that.
I think, well, first of all, I think that the difficulty that Your Honor is experiencing is resolved by reliance upon the contractual statute of limitations and the no damages issues. But Your Honor, I think Your Honor.
Right, although the judge did not rely on that provision for counts
3 and 4, but
3 and
well,
4.
she did say that the violation of the Condo Act failed because there was no damages, and then she goes on and she says, well, there's no violation. I'm sorry.
Applies to all those counts. I think that's true.
She also in granting summary judgment on the CPPA count, she specifically references constructive and actual notice of the bylaw amendment in order to establish that there was no violation. There was nothing that was not disclosed.
So your position is that if 5 minutes before the closing, the seller can file amended bylaws and with the recorder of deeds office, then at the closing, the purchaser is on constructive notice?
Your Honor, that's not what happened here.
That seems a little, seems a little absurd to say that.
That's
So
not.
there must be some play in the joints about this.
That's not, that hypothetical is not what happened here, though. What happened here was that it was recorded days before. I forget how many days, but
I think August 19th was the date of the recording.
Correct.
And I have some vague recollection it might have been a Friday, although that may be wrong. And then I think the first closing was like the next Monday or Tuesday, something like that. And then there was a second closing like a day later. So, and then after that, there's a few more closings.
Right.
That seems like a very short time frame to expect constructive notice to apply.
It is the law of this jurisdiction. And it's the law of this jurisdiction for a reason, because matters, records.
But do we have a case with this sort of factual setup where we've said, sorry, as long as it's, a second before closing, it gets recorded, you're out of luck.
It's the Bilal case that stands for that proposition. I don't know that the facts in the Bilal case are that the recording happened a second before and therefore you're out of luck. I just frankly don't know the facts of that case, but that's where the proposition comes from. And yes, the trial court did rely upon that. And here it didn't happen a second before. It happened many days before. And that constituted constructive notice to the individual purchasers. So for those reasons, Your Honors, the trial court's judgment should be affirmed. Thank you.
Thank you.
Your Honors, to start with the last point raised about the constructive notice issued, the case that was referenced earlier by my colleague is the Pearson against Pearson case.
I beg your pardon.
Pearson against Pearson, I'm not sure if I'm pronouncing that correctly. Against Pearson case, it's an older case out of this court. And in that case, the court did find that there was notice because an agent of the purchaser, an attorney, in fact, had affirmatively, there was evidence that the attorney had affirmatively gone to land records. This was the old days, so I'm assuming the attorney flipped through some books and actually reviewed the record before closing. And the court found that that sort of affirmative act was sufficient. But it cited to several other cases and said, if you don't do that, if you don't have facts to support somebody physically going and looking through the records, that's not sufficient. So that constructive notice would not be enough. Because of course, we're not dealing here with a blameless third party and there was an accident. What we're dealing with here is that there was a material change made to the amended bylaws. And counsel referenced several times that there really was no material difference. The amended bylaws are what added the restriction to the size of the decks. It's the last paragraph in the amended bylaws, and that's what adds the size restriction. That is a material change. Therefore, that needed to be disclosed by statute. The failure to disclose an omission in this context, a material omission can be fraud. So that failure to disclose that there has been a material change in the size of what you're purchasing,
Two
that
questions.
is sufficient to overcome.
The Bilal case, was that also a case, that's a constructive amendment case, was that also a case where the party actually did conduct a search of the land records, such that under your theory, constructive amendment would be, constructive knowledge would be justified?
I do not specifically remember.
See, I had the
circumstance
impression
of that case.
that that as long as it can be said you have a fair opportunity to check the land records, then constructive notice will apply because you're expected to take that opportunity.
Well,
Okay.
Your Honor, if I accept that premise that that is the holding of the Block case, and I don't know standing here,
Well, I'm not sure.
Your Honor's used the word fair opportunity. And Your Honor was correct in your recollection that August 19th is when the amended bylaws were filed. That was a Friday. It was at 12:35 p.m. On Tuesday,
How
the
did I
20th.
forget that?
Yeah. Tuesday, the 23rd is Mr. Mulligan's closing. The 24th was Miss Cow. So with that, and this is also the amended bylaws are signed August 9th. So they're signed 10 days before they're filed, which further goes to show that there really was no attempt to provide these owners with notice, statutorily required notice, that what they were purchasing, the size of what they were purchasing had changed. So I don't think that's fair.
How do you respond to the judge's grant of summary judgment on the developer counts? On the ground that there are no damages demonstrated?
Your Honor, I would say that the case law on the issue of damages says that an injured party doesn't have to prove exact damages as long as they're a reasonable basis for approximation. There is evidence in the record as to the value of the rooftop decks in the
You would think so,
purchase.
but what's perplexing here, I think, if I understand the how this happened, the defendants presented interrogatories that asked for, tell us your damages.
Yes.
And the answers did not tell any damages. So the defendants moved for summary judgment, and moving for summary judgment, if I understand correctly, said, look, we're entitled to summary judgment because look at their answers. They haven't, they've not made a demonstration that they have any damages. And if I understand correctly, the plaintiffs didn't respond to that by saying, oh, well, we actually do have damages. They seem to have left the subject, unrebutted. So the judge finds, well, there's no genuine dispute before me. There's no claim of damages here. That seems trouble. That seems a problem for you, doesn't it?
Yes, Your Honor, I will concede that our presentation of damages was not as thorough as it could have been. But the contracts themselves that had the dollar amounts in them were part of the motion, were before the court on the motion for summary
If you were
judgment.
asking for rescission of the contract, but you're not really asking for rescission of the purchase agreement.
Correct.
And there's no argument, but we paid too much. You know, we overpaid because we thought we were getting 400 square feet and we actually are getting 300 square feet. I don't know what the numbers are. I mean, that argument is made, and that to me may be a ground for upholding the summary judgment award on the developer accounts.
Yes, Your Honor,
Because one would think one could make an argument that there's damage. The value of our property is less than we thought it was.
Yes, Your Honor, and as I said, the value of the property was in evidence. And the issue of damages is an issue that generally is reviewed by the trier of fact. So our position is that it was simply inappropriate to do on summary judgment. It should be remanded back for determination as to whether what we presented was sufficient based on the amounts that are in the sales contracts.
So is that kind of boiling down to a concession? In your brief, you talk about the, you sort of try to make an argument that these claims are essentially claims for specific performance, which doesn't have an element of damages. Are you now sort of acknowledging, no, we needed to do a better job here, and you dropped this footnote with all of the actual value lost? But has your argument changed in that regard?
No, Your Honor, the claims for the contract claims are claims for specific performance, but there is no claim for specific performance, at least to my knowledge, for like a violation of the CPPA claim or the fraud claim. There would have to be, since we're not seeking rescission, we would have to provide damages. And I believe we have put forth the value of those cabanas, which can reasonably be construed as a damages calculation. If the court has.
I have a few more
Okay.
questions for you. Getting back to the claim against Erie
Yes,
and the objection to the amendment. The statute, the Condominium Act, provides that a challenge to an amendment of the bylaws is subject to a 1-year statute of limitations. I think that's 27C, if I remember correctly.
that is correct.
Did you comply with, I mean, it seems to me the unit owners and the association missed that 1-year deadline. How does that affect this in your view?
Your Honor, the 1-year deadline does not apply in this instance.
And why is that?
First, the amended bylaws are void. If they couldn't be passed in the first instance, then they have no legal force and effect. So the statute of limitations would not apply. Secondly, you have a third party. This is the issue with this scenario. You have a third party who's saying, oh, you had a year to challenge these bylaws. It's not a unit owner who's challenging the bylaws. You have a third party.
Well, I wondered about the
who
third
wouldn't have
party
standing.
standing, but I don't know that I have an answer on that yet. I mean, they are clearly identified as a third party beneficiary, you could say,
Yeah.
of those bylaws, and I don't know why that wouldn't give Erie standing to raise the limitations bar. And they could say, look, we rely on that, you know. It seemed to be final.
Yes, Your Honor, but the Erie also wants the court to ignore the earlier provision. This is a 2/3 vote of the owner can change it, because Your Honor, frankly, we brought this as a declaratory judgment because we knew there was an
And
issue.
actually,
dispute.
it's even worse for you in a way, because it was in the original, as I have been instructed
Yes.
and corrected. It was in the original bylaws.
Yes, there
So-
was a restriction in the
So
original
that
bylaws.
makes it even harder to argue that this was a timely response, and you know, you're bound by. I mean, I don't know if it's an answer to say, well, it's void ab initio, because
Well,
this gets to the statutory interpretation question.
yes, Your Honor. To look at it another way, instead of bringing this as a declaratory judgment, the Champlain could have simply breached the
Violate.
bylaws and waited for Erie to sue it, in which case that 1 year statute wouldn't apply. The purpose of that 1 year statute is when an association
Well,
takes an
the
action,
statute wouldn't, right, that statute.
that statute wouldn't apply.
But then you'd have a breach of contract.
Correct. But the purpose of that statute is when an association adopts bylaws, a unit owner has 1 year to challenge the sufficiency of it.
Well, that
That's the
doesn't
purpose.
limit it to.
It
units.
does not in the stat, but I would argue that nowhere in the condominium statute does it provide any rights like that to a third party, because what we have here is such a unique scenario where you have a third party who's specifically given rights in an amended bylaw in which they can veto acts of the association. The DC Condominium Act simply was not created to support that type of claim. That's why it's not in there, because it wasn't contemplated. The purpose of the DC Condo Act is to provide for the relationship between the unit owners and the relationship between the unit owners and the association. That's its purpose. It doesn't contemplate the scenario we have here, which is Erie.
Another question about the bylaws. One of your arguments earlier was that this was not an easement because it did not run with the land.
Correct.
Mr. Mugavero, I think pointed out that the bylaws do say they run with the land. Is that, how do you respond to that rejoinder?
I do not believe that statement's in the amended bylaws. I do think as a rule that amended bylaws by their creation run with the land. That is correct, but I'm not aware of a statement within the amended bylaws or a statement specifically in this section that says those restrictions run with the land. I just am not aware of that.
I may have misunderstood the point that was made earlier.
It's- I apologize.
Let me see if there's anything else I want to,
Certainly, Your
as
Honor.
long as I have you there. Okay, I think I'm going to let you sit down.
Thank you, Your Honor. I appreciate the court's indulgence.
Thank you. Counsel, the case is submitted and parties are excused.
All right. This honorable court is now adjourned.